Montana Supreme Court decisions that refer to a right of privacy. No, he insisted that we have it. And thank you, Bob, for standing fast, because the right of privacy in our Constitution has served the purpose of freedom in Montana. In Article 15, we talked about adult rights for all minors, except for consuming or purchasing alcoholic beverages, or unless certain fundamental rights are specifically precluded by laws which enhance the protection of such minors. The delegates debated all of these issues, and all of these sections during the debate period were debated in a scholarly fashion, in a respectful manner, even though there were members of our constitutional delegation that were opposed. Most of our sections in the Bill of Rights would pass by great majorities, but there were always 10 to 14 votes that would be in opposition. I remember, as Mae Nan does and all the other delegates, on March the 24th, when we adjourned, everybody walked to the front of our assembly hall in the chambers of the House of Representatives to sign the Constitution. I think we were all so delighted that all 100 signed that Constitution, even though during some of the debates there was a serious question as to whether or not all of them would sign that document. Section 16 is about the administration of justice. There had been an infamous case decided by the Montana Supreme Court that took away third-party rights. I'm not going to go into that in any detail, but it did take away certain rights that injured people had in the state of Montana. So that was inserted into Section 16. Section 18 abolished the defense of sovereignty in Montana. If someone were injured by some activity of the state, some employee or machine of the state, all that they would have to do if a complaint were filed was invoke what's called sovereign immunity. That's a doctrine that came from England, was created by the monarchy to make sure that the king could do no wrong and that everyone would respect the fact that he could do no wrong. We argue there's no king in Montana. The delegates had no trouble in agreeing that we should have that section. Section 26 added another right that we never had. It provided trial by juries, but it also allowed, in a misdemeanor case, a criminal matter, for 4 out of 6 to convict a Montana citizen. Our analysis was, if you should not be convicted for a crime unless the proof is beyond a reasonable doubt, how can you say that exists if there are 2 on a jury that say, no, we don't think that individual is guilty? So that section made it unanimous in all criminal cases. In Section 28, we added a provision that solved a problem for all those that are convicted, incarcerated, that have a felony on their record because they lose civil rights under our system of law. And to have those civil rights restored, normally, you have to have a pardon from the governor. We provided in Section 28 that full civil rights are restored upon the termination of state supervision. In Section 29, which is parallel to the 5th Amendment to the United States Constitution, you can't take anybody's property without just compensation. Our experience was, and we discussed it at the committee, There's a great deal of eminent domain litigation at that time. We were still in the process of completing the interstate highway system. The state would fight the landowner, force him to spend thousands and thousands of dollars to receive just compensation. But upon prevailing, there would be no payment by the state to satisfy the expenses that were required to protect your individual rights. We added to Section 29 a provision that if the landowner prevails, and I was asked this question on the debate floor, what do you mean by prevail? And I think I responded, if the landowner receives $1 more than what the state offered, he's entitled to be fully compensated. Section 35 is our last section that I want to mention. It provides that servicemen, servicewomen, and veterans may be given special considerations by the people. You have a Bill of Rights, 35 sections, that provide all the protection that anyone needs in a free society. The other sections of the Constitution deal with very specific matters such as lands and taxation and local governments, but the three articles that follow after that create the legislature, that create the executive, and that create the judiciary, are there for one purpose and one purpose only. And too many of our public servants tend to forget that the reason for those articles is to protect all the rights that we have in the Declaration of Rights. There's a lot more that could be said, because when we adjourned on March the 24th of 1972, those that were opposed to expanding rights for the individual had a great deal of financial resource, supported by the Chamber of Commerce, by the Farm Bureau, by other organizations, came very, very close to defeating the Constitution. And after the citizens of Montana narrowly approved it by 2,500 votes, they then went to the Supreme Court of the state of Montana. We all waited with great anxiety for that decision. It came down 3-2 in favor of the Constitution. Then they proceeded into the federal system, and like I've stated, in December of 1973, the last avenue for objecting to our Constitution was closed by the United States Supreme Court. I once again want to say that I'm very privileged and very honored to be on this panel, and I'm going to stop at this point, and I'm sure that our conversations with respect to the Constitution are going to be very informative and very educational, and I'm sure in the final analysis make us all fully appreciate the magnificent document that was created 40 years ago. Thank you very much.
Thank you, Wade. Is there any doubt why I had Wade lead off within this panel? He is still as articulate and charming as he was 40 years ago. Since Wade introduced Bob Campbell, I would like to also have the other delegates that I see stand to be recognized. I see Betty Babcock here. Arlene Reiser, Steve Golden, Lynn Harrison, Jerry Lindor, Phoebe McNeil, Grace Bates, who I believe turns 94 this next week. Did I miss anyone? I don't think so, but thank you all for being here. And of course, thanks to Wade for all of the kind things he said about me. As Bob Campbell used to say, Mae Nan was the youngest delegate to the convention, and she still is. I would like to ask you to open your constitutions, if you will, to one of the rights that Wade did not mention, and it's Section 4. I want to put in context the timing of us meeting in January of 1972. And one of the things that was foremost in my mind, and I think in a lot of the delegates, was the fact that the Equal Rights Amendment to the United States Constitution had been introduced, but it had not been ratified by the requisite number of states to become a part of the United States Constitution. And certainly for me, one of my abiding goals in the convention was to make sure that our Constitution had a provision that specifically prohibited discrimination on the basis of sex. Now, as you will read with me this section, it does a lot more than that. And this particular section, and I'm reading it now because I think both the comments that Betsy Griffing will offer as well as Justice Nelson will shed light on just how important this particular section of our Constitution has become. It's called individual dignity. The dignity of the human being is inviolable. Those words were not found in the 1889 Constitution. No person shall be denied the equal protection of the laws. Neither the state nor any person, firm, corporation, or institution shall discriminate against any person in the exercise of his civil or political rights on account of race, color, sex, culture, social origin or condition, or political or religious ideas. It is this particular provision of our Constitution that has resulted in several, and I consider them landmark cases in our courts in the last 20 years. Elizabeth Griffing has been involved in a number of those. One which was just argued before the Montana Supreme Court in Missoula last week, and which Justice Nelson is not going to be able to comment on. But because it is so important, and because I think it shows the continuing evolution of what our Bill of Rights means, I think it's important that we talk about that case and other cases that have recently been brought. One thing I think is really important to note, and why I think Wade's comments about Justice Nelson were so important, is that, you know, we do have 17 rights that were not in the 1889 Constitution nor in the federal Constitution. With respect to those other rights, all of which are very important, we have over 100 years of jurisprudence in Montana interpreting those rights, and nearly 200 years under the federal Constitution interpreting